I'm Sharon Stone. This is Engage. Florida's Resign-to-Run law is now at the center of multiple legal challenges in Central Florida, including the Orange County Clerk of Courts race and a challenge brought by Lake County Commissioner Anthony Sabatini over his recent campaign for Congress. The law has been on the books in Florida for decades, although state lawmakers have amended it several times in recent years, most recently creating an exception for candidates running for president or vice president. This law repeatedly leads to confusion and questions that ultimately impact voters, according to UCF political science professor Aubrey Jewett.
We have seen almost every election cycle candidates not quite understand what their obligations are under this law and not do it correctly. And so then candidates get fouled up. They either don't fill out the letter properly or they don't do it on time. It causes questions about whether they should be allowed to stay on the ballot for the new one, etc.
Jewett explains what the law means for people running for political office.
Florida's Resign-to-Run law says that if you're a current office holder and you are seeking another elected office and the terms of those two offices would overlap, then you have to file a resignation letter from your current office before 10 days before, in fact, you actually qualify for the new office.
Critics argue the law discourages qualified candidates from entering a race because they risk losing the job they already have. Supporters say the law discourages elected officials from campaigning for another job while still serving in their current one, and it also gives potential candidates advance notice that a seat could become vacant.
Arguably, you can point and say, well, look, because they did that, and the deadline was 10 days before qualifying for a new office, that allowed other candidates to get in the race. And thus, we didn't have special elections for a lot of seats that we otherwise might. But there's also potentially a cost involved in that. Sometimes you might go for a longer period of time with people that don't have representation. For resigning from a local office like a county commission or a city council, that's not such a problem, that because the governor can do interim appointments. But for somebody to say that's a state representative or a state senator who's looking to run, if they leave their office, the Florida Constitution specifically says those offices can only be filled by election. They're not filled by gubernatorial appointment. So you might actually end up having many months where people don't have representation up in the legislature.
Lawmakers have changed the law in Florida before.
So let's say, again, you were a sitting governor of Florida and you wanted to run for president, or maybe you were under consideration to be somebody's vice presidential nominee. Well, under the strict Resign-to-Run law, when it was applying to all offices, that would mean even if you were a governor with like 2 years left in your term and you were going to be maybe selected as somebody's vice president, well, if you ended up not winning the vice presidency, or your candidate didn't win the presidency, you'd still have to leave your job as governor. And most states don't, require to do that. And so Florida's actually changed its law several times. We changed it to say that you don't have to resign when you're vice president when Charlie Crist was under consideration for being vice president. And then they changed it back when Rick Scott was in office to say, well, no, you still have to resign even then. But then when Ron DeSantis was going to run for president and eventually did, they changed the law again to say, okay, well, it doesn't apply if you're running for president.
The law isn't just the subject of debate. The Resign-to-Run rules are at the center of two legal disputes with ties to Central Florida. One involves Lake County Commissioner and attorney Anthony Sabatini. Earlier this year, Sabatini announced he was running for Congress to replace retiring U.S. Representative Republican Daniel Webster. Instead of resigning from his commission seat as required by law, Sabatini sued. He said that Florida's statute on resigning to run treats candidates for federal office differently than candidates for state office. I asked him why he was willing to take this fight to court.
Well, the Resign-to-Run law is very weird and very complex, and there's different issues with it. But most of the issues revolve around the federal candidacy part, which is the second major part of the statute. And it's very, very legally different than the state part. So if you're a state office holder and you're seeking to look to get another state office, the law just requires you to resign before you can qualify. It's not legal to do that for a state office seeker seeking federal office because that would violate the qualifications clause of the U.S. Constitution. So they came up with a really technically weird and interesting way of trying to get around the law, which is to say you're not prohibited from qualifying for federal office if you're a state office holder. Instead, we're going to create a legal fiction. We're going to treat your non-resignation as an automatic, irrevocable act of resignation. So it's very strange. It's quite literally illegal. It's the only state in the entire country that has it. There's only 5 states that have Resign-to-Run. The only one that has this really strange part regarding seeking federal office that's not also in the state constitution is the state of Florida.
A federal judge rejected Sabatini's request to block the law, ruling he would have to resign from the Lake County Commission if he wanted to run for Florida's 11th congressional district in the U.S. House. Given his options, Sabatini withdrew from the congressional race last month and remained on the Lake County Commission. He says regardless of whether someone supports or opposes Resign-to-Run, the law is a frequent source of litigation.
Some people like the Resign-to-Run law, some people don't, but at the end of the day, I don't think it does anything positive for Florida. It does create a lot of election law. It creates a lot of election litigation.
Sabatini is also involved in another Resign-to-Run case in Central Florida. This time, he is the attorney arguing that the law should be enforced. He's representing Rick Singh in a lawsuit seeking to remove Orange County Commissioner Maribel Gomez Cordero from the ballot in the Orange County Clerk of Courts race. Singh and Gomez Cordero are 2 of the candidates for Orange County Clerk in the August primary. The suit claims that Gomez Cordero violated the law when she filed to run for county clerk without resigning from her current commission seat.
So she had to have submitted a Resign-to-Run law 10 days before qualifying, which was, I think, a month and a half ago. And she didn't do it. It's a harsh remedy, but the statute requires her to be removed from the ballot. So she's most likely going to be removed from the ballot in her request for Orange County Clerk of the Court. This statute is written in such a strict way that it actually will disqualify her from the office she's seeking. So instead of just being like, okay, well, let me do what I can to fix it, it doesn't even allow for that. She'll just be struck from the clerk's race.
According to Sabatini, the final hearing on this case is in 2 weeks. We reached out to Gomez Cordero, but never heard back. Engage is a production of Central Florida Public Media. Subscribe wherever you get your podcasts so you never miss an episode. Richard Copeland is our senior producer. I'm Sharon Stone. You can reach us anytime with questions, comments, or story ideas. Send an email to engage@cfpublic.org. Thanks for listening.